It's Guy DiMartino. Today, I'd like to talk a little bit about how divorce can impact your ability to take under somebody's will. And this is the story. This is the story of Jack and Diane. Jack and Diane were married. When they were married, they go ahead and they put together a will, and they make each other the personal representatives under the will, and then they give the other person everything that they have. So usually, typically, when one spouse passes away, they leave their stuff, usually most of their stuff or all of their stuff, to the other spouse. So that's the way the wills were written, going each way to Jack and to Diane. And so then a few years later, Jack and Diane decide to go ahead and get divorced. Now, Jack and Diane have a pretty decent relationship even after the divorce. They're friends, they go out on dates sometimes, they still care about each other, and they still wanted to take care of each other. But what happens is that Diane passes away. And so Jack goes ahead and says, well, I'm supposed to be the personal representative under the will, and I'm supposed to get all Diane's stuff. And then there's a dispute. And the kids say, yeah, I don't think so. And Jack says, but I'm in the will. And the kids say, well, there's a law. And the law is that if you are to take under a will and you end up getting divorced after the will was written, then any proceeds that are supposed to go to you under the will are revoked under the law. So what would have protected Jack and Diane for to have their wishes actually come through, even if they were divorced and wanted to leave their stuff to their ex-spouse because they still got along, they still liked each other, they still wanted to take care of their ex-spouse, just they couldn't live together anymore. What they should have done was, after the divorce, enter and write another will. If the will was written after the date of the divorce, then the law that triggers would say that if you have a benefit under a will and you get divorced, any benefit is hereby revoked. So the way that they could have resolved this situation, which a lot of folks do not think about, would be just to go ahead and write another will and specifically state, it is not my intention to have my ex-spouse written out of my will. You think that this doesn't happen? Well, I can tell you that in the last month, I received 2 phone calls from folks inquiring about this factual scenario. I've seen this also happen a lot of times in life insurance proceeds, but that will not be affected by the divorce settlement or the divorce agreement. So if Jack and Diane had life insurance, even after the divorce, if they remained beneficiaries on their life insurance, it would still go under the beneficiary designation. So there you have it. Once a divorce happens, you are practically written out of the will by operational law. Some people like to say, well, the law says that what you did was you predeceased your spouse for when it comes to taking under the will. If you have any questions about a Northwest Indiana estate planning or probate matter, you can always give me a call. Until the next time, I am Guy DiMartino. Have yourself a great day.